Good afternoon, and welcome to the fourth of a five-part webinar on orchestrating your company's forces to deal with delay and changes on a construction project. My name is Steve Berkowitz. I'm the president of a law firm, Berkowitz and Associates. We deal exclusively in construction issues. We work with the Moment Group. The Moment Group is a consulting firm which evaluates delays and delay damages and also provides scheduling services. The purpose of this webinar is to help your company become more effective in the situation where a delay has occurred and somebody, either the contractor or the owner, is seeking to be made whole due to the costs which were created by the delay. So, as I said, this is the fourth of a five-part series, and the first webinar, we talked about orchestrating your company's forces. Now, what that means is the various departments in your organization must work together if you want to be able to establish entitlement to compensation for damages or costs incurred by virtue of a delay. When I say your different departments must work together, a organization is obviously composed of various departments. It may be only one person running all those departments, but there are various departments, and all of those departments have an integral role in establishing your entitlement to delay. So, you have the field personnel. They are critical in creating contemporaneous documentation. Contemporaneous documentation is documentation that was created at the time that the event was occurring. So, the daily job logs, the foreman's logs, all these logs which are created must be created in the field because they have to be created contemporaneously. It's not good enough to reflect and create your picture of what happened in documents after the fact, because courts and fact finders, and even just people, we're talking about people here, people give special credibility to recollections, documents that were created at the time that an event was occurring. It has special authenticity. And when you can look back at a document and you can be sure, because of either your business practices or your personal practices, you can be sure and you can testify that that document was created at the time this event was occurring. It has special authenticity. And the courts and people and juries and arbitrators and owners and contractors are all going to look at that document in a clear eye, knowing that there were no motivations to change anything, or your recollection of the events after the fact, knowing the situation that you have. So you have your field people, you have your accountants who are creating your billing, who are recording your costs. All of this, these different departments are working together to create the picture. You have your management, the people who are responsible for the administration of the contract. Those people have to be making sure that somebody, it could be management, it could be a person they designate, somebody has got to be reading the contract in order to determine what are the requirements in the event of a change in a situation, a delay, a change order. There are going to be certain requirements, certain documenting requirements, certain accounting requirements, certain time requirements. And all of this, somebody in your organization has got to be keeping track of and knowing what are the contractual obligations for your particular project. So that was the organization. That was the first webinar. The second webinar, we talked about documentation. Now I'm spending a little bit more time on reviewing where we are, because in evaluating your claim, we're going to use the information that was generated during the first few webinars that we had in order to allow your company to make the critical determination as to what the next step is after the project is ended. There are losses that need to be recovered. Somebody's going to have to make a determination, and what we're going to talk about today is how we're going to make that determination. But in order to talk about that, we need to discuss where we're going to get the information. So we talked about documentation, and I've been talking about documentation just about this whole webinar. And the reason is because documentation is so critically important. We talked about a quote during the documentation webinar. I can't recall who said it, so I can't give credit, unfortunately, but I can tell you the statement's rather simple. It's documents, documents, documents. Documents change the whole equation. And we talked about the example of the NSA and Eric Snowden showing documents and how much credibility those gave to his statements. Well, documents in a construction project have this similar impact in that they're critically important. The schedules which were made at the time, you can't really go back after a project is done and create a critical path method schedule, a critical path schedule after the fact, because you're really playing with an unfair hand in that what activities were delayed, and the special authenticity that the contemporaneous document, being the schedule which is created at the time before you know about delays which may occur in the future, that schedule is as one of the documents that you're going to need, as well as the other documents that we talked about, the logs, the accounting documents, all very critical, and documents were very important. And then we talked about, on the third webinar, the critical path, that method of keeping track of the scheduling in a contract, and the time impact analysis that you may be able to create out of that critical path. And the time impact analysis is going to be an important feature in determining the amount of your delays, the amount of your damages. So, without further ado, let's embark on evaluating your claim. Who is the owner? It's a rather peculiar issue, a question to ask in the first question of evaluating your claim. But who is the owner is critical in determining the enforceability of the various terms of your contract. Let's face it, this entire webinar is really about contracts and how you're going to prove your entitlement under the contract, because a lot of times clients call me and they ask me, hey, do I have a claim here? And I say, you have to give me the contract. You have to tell me who the owner is. And the reason I say that is that who the owner is going to determine which statutes are going to apply to that contract. So a contract may have a lot of good language in it. It may have a lot of bad language in it. The statutes are going to determine, or the laws which are predicated on who the owner is going to determine how the terms of the contract are going to be applied and whether or not they're going to be enforceable. For example, in the state of New Jersey, there are 3 statutes which make a no damage for delay clause in a contract void and unenforceable against public policy in certain situations. Now, those three statutes, they all say just about the same thing. So why are there three statutes? Because they apply to three different kinds of owners. Now, there's a statute for local public school contract law, excuse me, public school contract law. There's a statute for local public contracts, which are municipalities. There's a statute for county colleges. There's a statutes for state colleges. There's statutes for various organizations. There's even statutes for the Atlantic City Expressway. Each individual, either administration or public entity, is going to have its own statutes which govern how their contracts are going to be interpreted. So that's why who the owner is critically important. So you can make a determination, and you can do this yourself with the help of the internet. You can make a determination as to who is the owner and which laws are going to apply. Documentation, we've already spoken enough about documentation, but as you can tell, and as we'll discuss later in this webinar, documentation is critically important, and it's an integral part of evaluating your claim. The law, we just discussed how who the owner is going to determine what the law is. Make no mistake, your contract, your entitlement is going to arise from your contract, and your entitlement may fall based on your contract if you don't comply with the necessary notice provisions. And in addition, there may be certain proofs established in your contract necessary for your entitlement, such as requirements of a change order, requirements of a delay claim. They may be set forth in your contract, and your contract is interpreted under the law. And finally, the facts. Now, I understand people who own companies, people who own businesses, they don't go to work every day because it's a hobby. It's because it's their livelihood. It's what they do. And when they are damaged, they want to get compensation. But you can't let your desire to be compensated you can't allow your desire to overshadow the facts and whether or not what occurred really gives you entitlement. And we can talk about compensable delays and non-compensable delays, and we will talk about that later in the webinar. But the facts need to show that the delay was not contemplated. The facts may show active interference on behalf of the owner, in which case there are certain statutes which are going to give you more entitlement than you would have had without that statute, which more entitlement than you may have based on the contract and the terms in the contract. What the nature of the changes that occurred on the project, whether they were what they call a cardinal change, if it was something that really affected the entire flow of the project. I could go on, but the point is that the facts are critical in making a determination of what your next step is going to be. Okay, so now once you've made your preliminary determination, we have to establish your entitlement to damages. As I said, the first place we're going to look is the contract. The contract, it's almost like you're moving to a different country. There are certain countries that if you steal a loaf of bread, you get your hand chopped off. Why? Well, that's the way that's the constitution of their country allows that sort of punishment for that sort of crime. In our country, the penalties are different, and that this is based on our constitution. Well, I analogize this to a contract. Once you have entered into a contract, once you're performing under a contract, your entitlement to is based solely on the terms of that contract as they're interpreted by the laws. But you always have to start with the contract. So when you are under a contract, it's like you're moving to another country. You're in the country whose constitution is that contract. It's the best way to think of it. The project documentation, that documentation we talked about, which was so critical. Well, the first question is, do you have it? Do you have the schedules? Are they updated? Are there meeting minutes which are indicating that the schedules are followed, are not followed, are not updated? Documentation, 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 critical. It's critical, and don't kid yourself. Either it's there or it's not. Basically, at this point of the evaluation, we're just checking off the box. Do you have the contemporaneous job logs? Do you have the schedules? Do you have the detailed bills? Do you have the notices? Critical, critical, critical. Did you make the notices? Is it in accordance with your contract? That's where the management part of your organization, which evaluated the contract, is going to be able to tell you, well, look, this is what you need. You need A, B, and C. And I can tell you something from being in front of a judge. If there is a reason for something to be in a contract and you don't have it, you're going to have a big problem almost no matter which laws you're looking at, which laws your project falls under. Responsibility. This is where we can talk about compensable versus non-compensable delays. Now, again, your contract is going to tell you standard things which are non-compensable from a financial perspective are strikes, force majeure, unusual weather, unusually severe weather may be compensable. Unusual weather is not necessarily compensable. Injunctions, legal stops in the project, even if they are beyond your control, there may be something in that contract. So, for example, if a bid challenge occurs, we'll talk about when we're doing a project evaluation, which is the next webinar, we'll talk about whether or not delays that occur before you have a final signed contract are compensable. And I'll tell you something, they're not. So you've got to look at not only when you sign the contract, but also when the other party signs the contract, because until that time, there's the ability for you to change the contract, and you may not be able to be compensated for delays that you incur at that time. But those are the non-compensable delays, and those are the usual non-compensable delays, but they'll usually be set forth in your contract. Compensable delays are owner's interference, lack of access to the site, delays in inspections or approvals, which would be a third party, not inspections by the engineer, obviously, but inspections by the town clerk or somebody, the Department of the department that gives the building contracts, that gives the building permits, DSA. Delayed issuance of change orders, that can be a compensable delay. Design errors and omissions, that's another delay that you can seek compensation for. This is just a general outline, but that, along with your evaluation of the documentation, is going to allow you to make a determination as to how much damages you're entitled to. And that's what we're going to do now. Once you've established that you have entitlement, how are we going to determine what is the damages? Because what we're really looking for is an answer to the question, is it worth taking the next step? Even if you don't hire an attorney, if you don't hire a delay damage expert, the time and resources and attention that it is going to take for your company to recreate the situation to show that you're entitled to compensation is a big undertaking. So, in order to determine, because as I said before, we're all in this here to make money, because that's why you go to work and that's why your company is doing what it's doing, is to make damages. The question to make money. And so the question is it worth taking the next step? So we're going to be looking at the audit information. And when I say the audit information, I'm talking about the your financial audits, your schedules, really establishing not only how much money is lost, because that's usually pretty self-evident, but do we have the damages? Are we entitled to damages because of that time lost? So, for example, if a big part of the delay and the time lost is attributable to a non-compensable delay, well, then your damages are not going to be very great for that project. So that's why you really got to look at the information that you've compiled through your documentation to make the determination of whether or not you have enough damages to take the next step. Your cost records, those are your accounting people. Are they not only calculating costs, because everybody calculates costs. That's primarily the reason that you have an accounting department, is to calculate your costs. That's important, but more important is the allocation of those costs. Are those costs allocated to a particular task? And then we're going to have to establish whether or not that task was compensable. Was it a compensable delay that delayed the task, where, and also whether that task was on the critical path? So did it really make a difference in the delay of the project, and are you entitled to compensation for that delay? Now, the most hotly disputed issue is home office overhead versus field office overhead. It's pretty clear that field office overhead is usually a direct cost, because why else would you have that office out in the field if it were not to work on a particular job or to monitor a particular job? So it's fairly clear that the field office overhead are really direct costs to the project, and as long as those costs are compensable, that will add to the amount of your damages. Where people get tied up is in the home office overhead. And the Eichle formula, I'm sure that you're all familiar with that. We should talk briefly about what you need to establish an Eichle formula. Now, the Eichle formula was created 40 years ago, and it's been darn near death at times by judicial determinations that it does not create the a quantum of damages necessary to establish legal entitlement. And it has been revived, and certain jurisdictions have awarded damages and have established that the Eichle formula is a reasonable way of determining damages. But what you're going to need in order to do your Eichle formula is your audited financials, so that you can determine what is the cost of your home office overhead, your duration of your delay, which is compensable, meaning that the delays, it's not concurrent with another delay. You're not counting the same delay twice. In order to get the duration of time for a compensable delay, concurrent delays can only be counted once, and they must be on the critical path. Also, you're going to need detailed job costs and billings. With the job costs, billings, audited financials, you're going to be able to make a determination as to how much of your home office is allocatable to a particular project, multiply that by the duration of time, and you're going to have a number for your home office overhead. Now, I can't make a determination, I can't make a statement of whether or not the Eichle formula is going to be applicable in your particular situation. Why? Because the applicability is going to depend on the owner and the jurisdiction. So, but that is a way to establish your home office overhead. Now, in your home office overhead, you're going to be taking into consideration the ownership costs of the property, your corporate taxes, unassignable insurance costs, your utilities, your maintenance of the offices, the office staff salaries. All these things are going to come into play. But the determination of your amount of damages should be tempered by the kinds of costs which you have incurred. Okay, we talked about who is the owner. Now, I'm just going to give an example here of a New Jersey statute and how, if you in New Jersey, if the owner is a municipality, you're going to have certain entitlement that you wouldn't have if your owner was, say, the state of New Jersey or something like that. There may be a no damage for delay clause in your contract, which would preclude you from getting damages specifically due to a delay. However, as I mentioned before, there are certain statutes which basically make such clauses in the contract void and unenforceable and against public policy in certain situations. Now you have to look at the law and see what the certain situations are. If you want to hire a consultant or a lawyer, I would suggest that you do that because the experience in dealing with these statutes can make the analysis completely different than a person who has not experienced how a judge will interpret a lot of these statutes and who has not argued in front of the judge until his face turned blue about why a particular owner delay is active interference in a contractor's project. Well, let's just read the bolded and underlined portion of this statute. And it says, notwithstanding any other provisions of law to the contrary, it shall be void, unenforceable, and against public policy for a provision in a contract entered into under, and this is under the law which allows municipalities to enter into contracts, to limit a contractor's remedy for the contracting unit's negligence, bad faith, active interference, tortious conduct, or other reasons uncontemplated by the parties that delay the contractor's performance, to giving the contractor an extension of time for performance under the contract. In other words, the contractor is entitled to damages. He may not be limited to only being granted an extension of time, which may give him relief from liquidated damages, but not compensate him for the costs that he incurred. Therefore, this is an example of how the owner, the identity of the owner, will have a critical impact on your interpretation of your contract. And the 5 things that we talked about, those being the contracting unit's negligence, bad faith, active interference, tortious conduct, or other reasons uncontemplated by the parties. Those are 5 reasons which you are going to need to establish in order to allow this statute to use this statute to give your company entitlement for damages under the contract. That will conclude our webinar for the portion under evaluating your claim. I've hope I've given you a framework in which you can use the data that you compiled based on the suggestions in the first 3 webinars to evaluate your claim. And if you may not necessarily evaluate your claim yourself, but if you can look at the things that I mentioned, you will be able to make a reasoned determination as to whether you want to take the next step and whether you want to hire a person who has experience in front of a judge or an arbitrator or an administrative body to present your claim. Because make no mistake, presenting a claim is a very labor intensive activity. And whether you do it yourself or you commission a licensed professional, it's a big endeavor and it should not be taken lightly. I thank you very much for listening to this webinar, and we will see you next month when we will talk about applying what we've learned to a real example. Again, thank you and have a good evening.